Hi, this is Brian Dolan with the law firm Pepper Hamilton. Each month, Pepper partner Greg Nowak hosts a webinar for West LegalEdcenter, which focuses on issues that are affecting private funds and their managers. You can download a copy of the PowerPoint slides that the presenters went through by visiting Pepper's Insight Center at www.pepperlaw.com, where this podcast is posted. Thank you.
Thank you very much, and good afternoon, everyone. This is Gregory Nowak. I'm a partner at Pepper Hamilton in the Financial Services Group. My practice is focused on investment funds, basically dealing with other people's money and making sure that the regulators are receiving their due. I'm joined today by one of our special counsel, Mark Dabberton. Mark is a former banker, so I'm going to actually ask Mark to introduce himself.
Thanks, Greg. Yes, as Greg mentioned, I worked for the OCC for 5 years. That's the federal agency that supervises national banks. And I then spent 18 years working at major banks. Those banks included what was then called Morgan Stanley Discover, JP Morgan Chase & Company, and Citibank. Along the way, I've worked for a few law firms. I've been at Pepper Hamilton since September of 2016. And I've done quite a bit of work involving merchant cash advance.
Thanks, Mark. Those of you who have attended our webinars before know that we try to focus on cutting-edge topics, things that the industry in asset management and banking are thinking about and investigating. And probably one of the most exciting innovations we've seen in recent years is the so-called merchant cash advance. Merchant cash advance is a specialized form of accounts receivable factoring. Now, factoring has been around for ages. Companies, generate accounts receivable and then sell those accounts receivable to investors. Once the account receivable is sold, that ends the investment. There's actually an exception in the Investment Company Act of 1940, so that shows you how long this goes back, for funds that are focused on factoring. A merchant cash advance, however, is a different animal. It's not factoring per se because, correct me if I'm wrong, Mark, the receivables don't exist yet. And basically what the merchant is doing is selling future receivables. So if you take the archetypical business that generates a substantial cash flow, it finances its business in a number of different ways. It sells securities, it sells debt, it borrows money, or it uses profits that it builds up, and then it takes those profits, take a restaurant for example, and buys the foodstuffs that will be turned into tonight's dinner. And then once the dinners are sold, the merchant has either cash from the people who have attended the restaurant, or it has a receivable in the form of a credit card receipt. The merchant cash advance gives the restaurateur, in this example, financing before the receivable actually exists. So it's a purchase of future receivables. Now, this exists in nature and has existed for hundreds of years. John Maynard Keynes, the great British economist, made his fortune in corn futures. And so the concept of buying a product for future delivery is not alien, and the regulatory landscape around that is actually very well established. In the United States, that's regulated by the Commodity Futures Exchange Commission and is regulated under the Commodities Exchange Act. But in each of those instances, there has to be a future on a commodity. Accounts receivable, to my knowledge, have never been held by anyone to be a quote-unquote commodity as defined by the regulators, and it has never been held to be a quote-unquote security per se, unless it falls into the concept of a loan. So we're dealing with an area of the law that, believe it or not, is somewhat of an unprovided for case, which means that a lot of what we do in providing advice to investors in merchant cash advance companies or investors into merchant cash advance participations or syndications, or the actual extension of cash in the purchase transaction that is a merchant cash advance, we're arguing by analogy and, as usual in this industry, reading the tea leaves that the regulators have laid out for us. So I've given you a general overview, but I'm going to ask Mark to delve a little bit deeper. What is a merchant cash advance from the point of view of the bank regulator or from the point of view of the Uniform Commercial Code?
Right. So Uniform Commercial Code, a case from the New York Supreme Court noted that purchases and sales of future receivables and sales proceeds are common commercial transactions that are expressly contemplated by the Uniform Commercial Code. So you have no problem there. Where the main issue with a merchant cash advance is that the advance could be recharacterized as a loan. So even though factoring has been around for a very long time, merchant cash advance came into popularity during the last financial crisis when banks were generally less willing to lend, particularly to small businesses. And small businesses looked for alternative sources of funds and found those funds from merchant cash advance providers. The effective APR on a merchant cash advance can be very high, 150% or higher.
Well, wait a second. An APR essentially means you have a loan and a use and forbearance of money.
Correct. I'm getting there.
Okay.
So it can be very high. The justification for that effective APR, if you were to calculate such a thing, being much higher than a loan is really fundamental to the difference between a merchant cash advance and a loan. Namely, the merchant cash advance provider is investing in the business. By taking those future receivables, the ability of the merchant cash advance provider to be repaid and recognize a gain on its investment is all contingent upon the performance of those receivables, or at least that's how an MCA ought to be structured.
All right, so hold on a second. We're not saying that the MCA firm has invested in the company, into the merchant, right?
No, what they've done is they've purchased future receivables.
So they've become a partner in the collection of those receivables, in effect.
In effect, because the performance of those receivables, which all depends on the success or failure of the business, is going to determine whether there are funds available to pay the merchant cash advance provider. A couple things that are key, and I'd like to actually, if we can turn to a slide that I have in the materials, a case called LG Funding versus Snowstar.
That's on slide 4 for those of you who have the materials.
It's a case pretty recent, New York Supreme Court case, December 2017. New York cases are very relevant because New York courts have done a really great job of providing some structure around the differences between a merchant cash advance and a loan, and in doing so, guidance regarding how a merchant cash advance agreement should be structured. What are the components that you would have in that MCA agreement that would differentiate what we're talking about with a cash advance from a loan?
Let me just interrupt for 1 second. We did receive a request from one of our listeners asking, has the program started yet? This is a question from Arizona. We do hope that you have the audio and the materials. We're about 9 minutes into the program at this point. Sorry, Mark. Go ahead.
Sure. So LG Funding is a good case because it relies on some other relatively recent cases from the New York court system, one called Canine Bites versus Active Arch Capital Group, another case called Ibis Capital Group versus Four Paws. And what these cases have done, like I said, is create a structure for how to craft a merchant cash advance agreement so it won't be a loan. So 3 core factors have been recognized, again, by New York courts. Keep that in mind because New York courts don't dictate the law all over the place, but and I'll get to how you can leverage New York law, hopefully successfully, in these agreements. But there are cases from other jurisdictions, so we'll be looking at some of them in a bit. So anyway, under New York law, there's 3 factors that differentiate an MCA from a loan. First, whether the principal advanced is put in hazard. So you think about it, a loan, which is repayable absolutely, principal's not placed into hazard to the same extent that I just mentioned, where you're purchasing a future receivable, and the performance of that receivable, ergo the business, is going to determine whether or not you recover anything. So principal needs to be placed in hazard. Next, second, the existence of what's called a reconciliation provision. Very common in these agreements for the merchant cash advance provider to try to contract for a regular flow of income. So what they'll do is they'll specify, it's usually a daily payment from the merchant to the provider, MCA provider. Now what that daily payment is supposed to be is an approximation of the amount of receivables that will be collected each day. By the way, the provider usually takes only a percentage, not all of those receivables.
Yeah, so let's take a step back because I think we sort of jumped ahead right into these 3 features. Give me the terms of a classic MCA contract.
Sure. So in a classic MCA contract, you're going to have a purchase. First of all, it will be headed a sale and purchase agreement.
So I'm purchasing $10,000 of face amount of receivables.
Right. And typically what you're purchasing is going to be, you're going to advance a sum of money to that merchant. And say I advanced $5,000 to the merchant. In exchange, they may give me $10,000 of future receivables, because that's how I'm going to recognize a potential gain on, and I'll call it my investment, my purchase, is that it's not interest, it's that I'm getting more receivables back than the amount I advanced because I've taken on a gamble. I've risked my capital on this business performance, and so therefore, as my reward, I'll get more back than what I advanced. I'll get more back, and my purchase receivables amount will be greater than the amount advanced.
But this is no different than the way the Fed sells Treasury instruments off of its balance sheet. It sells them for a discount. It's no different than the way the Treasury auctions off government securities. The fact that you're paying a discount for the realization is the way you make profit. It's the spread.
Correct. As
the investor. And so, no one should feel that in and of itself is indicative of something wrong. Now, obviously, the bigger the spread, that represents the risk that the investor is willing to take.
Right.
So if it's $10,000 face amount of receivables and the purchaser is only willing to pay $5,000 for those, then the purchaser is saying there must be some risk of collection. And what happens, you mentioned the existence of a reconciliation provision. How does that cut?
Okay.
Do you need to have a reconciliation provision, or is the presence of one damning?
So typically you would have a reconciliation provision. Whenever you have a specified sum of money that's going to be paid on a regular basis, then you'd have to have a reconciliation, because again, that specified payment is an approximation of my percentage of receivables that would be collected each day. So if I contracted to purchase 15% of the receivables that merchant collects each day, what we do is we figure out what is approximately 15% of their historical receivables that they collect. Now you pay me that amount.
So this is different than a traditional factoring of receivables, where I have $10,000 of receivables and I buy those for $7,500, and that terminates the relationship I have with the vendor at that point.
Correct, because here they don't exist yet. And so those receivables have to come into being. As they come into being, I'm entitled to a certain percentage of those receivables as they materialize. And so we do our best to approximate what that's going to be worth. And so I have, again, a regular flow of income because it could go up and down. We decide, well, we're going to have a daily payment amount of X. Now, I mentioned that there were, three factors, and they are very material to this discussion of what a typical merchant cash advance agreement consists of. So we already covered that my principal is now in hazard. I'll get into what a reconciliation provision is in just a second. But the third factor is that there's no specified repayment period. It's however long it takes for those receivables to materialize and accumulate to the point where now I've received the entire amount that I've specified that I've purchased in exchange for the money advanced.
But hold on a second.
Yes.
Let's go back to the model. I am giving you $7,500, right? So what are the repayment terms? As the purchaser of those future receivables, what am I getting? 50% of your future receivables up to a cap?
No. So the way it would work is typically I purchase, let's say, 15% of your daily receipts.
For how long?
For however long it takes for me to receive $10,000, if that's the amount of receivables that I've purchased in the aggregate. So I get a certain amount each day up to the point at which I recognize my entire purchased amount. But it can take forever for that to happen or never. It all depends on the performance of those receivables and the business, because if there are no receivables, if the business absolutely fails, then there shouldn't be any default at that point. As the merchant cash advance provider, I've lost my gamble. Now, I can tell you that this is how it should work in the perfect world. MCA providers want to be repaid, and so it's a common practice for providers to seek to get some additional collateral, have personal guarantees that attempt to provide for an absolute obligation to repay.
But they're problematic, aren't they?
Those are problematic. That's what I was going to get to. You can't have it both ways. You've either got to have an MCA or a loan. You don't have both. And so I mentioned there's a couple of cases that do a good job of kind of explaining how this works in practice. So the case I began to talk about a while ago, LG Funding versus Snowstar, give you, one of the things the court noted, again, after citing those three factors, is that the agreement described a purchase and sale. There was no promissory note, no repayment schedule, because I don't need one. We've already identified how this payment's going to work, so I don't need a repayment schedule. In fact, there can't be one. And that there were guarantees, but they were guarantees of performance, not an obligation to repay. So let me give you an example of a performance guarantee. So I require the merchant to collect receipts each day. Those funds collected have to be deposited in a particular account to which I have access so I can get my 15%. If those funds are not deposited, if no funds are deposited, I've got a default. And now a personal guarantee can kick in, and both I have a violation on the part of the merchant, but a guarantor is now on the hook as well for that default. What happened in that case? It wasn't that the specified amount wasn't paid. It was that funds were not deposited into the designated account. I can also say that if you're not going to deposit the amount that we've agreed upon is the daily amount that needs to be deposited, you have to tell me several days in advance, let's say 3 days in advance. That doesn't happen. Now there's, fewer funds than I anticipated. I'm left, underfunded myself as the provider. That's a default. It's not an absolute obligation to repay, but there is an obligation to provide notification. Okay, another example, a quick one.
Notification of what?
Notification in that case that the funds are not going to be deposited in the amount you're expecting because I haven't had a good month. And so that's advance notice that I can contractually require, and I can assert a default if you don't give me that notice, because it's very material to my business risk.
Okay, so let's go back for a second and summarize. I am a merchant, and I need $200,000 of funding for something, and I agree to sell my future receivables. And in order for this contract to be enforceable, I have to essentially sell receivables for the next 2 months up to 15, 20, 25, 30% of whatever receivables I generate.
Right.
Now, what if that 30% of the receivables I generate pays me $500,000? I only advanced $200,000. Is that my windfall, and I can keep that?
Because again, there's both a specified payment and a specified percentage of receivables that you're purchasing, but there's also an overall purchased amount that will be specified in the MCA agreement. And at that point, once the overall purchased amount is reached, then the obligation ends. So there's really, three things that you'll see in an MCA agreement. You'll see a specified payment. I mentioned that's usually daily. You'll see a percentage of receivables that I'm entitled to each day, and that's so the business can keep operating. For 100%, you'd shut them down. So we cap that at, say, 15%, but then there's also this overall purchased amount, and that's, as I mentioned at the outset, that's going to exceed perhaps considerably the amount advanced, but once that amount is reached, then the obligation ceases and the merchant cash advance agreement terminates at that point.
So this is actually more favorable to merchants than typical bank financings, which tend to use a borrowing base and tie up 100% of your receivables and cash, and you can only spend them when the bank says you can spend them. So maybe that's the allure and why people are willing to go to a merchant cash advance provider as opposed to going a traditional bank that ties you up 6 ways from Sunday.
It's also more favorable in that the underwriting for a merchant cash advance typically is based on reviewing bank statements, because you're trying to see the funds that are flowing in and out of this business, and it's less of an intensive practice than a full-blown bank underwriting. It's also much faster. So if my business is in trouble, I need funds in a hurry, I'm going to go to a merchant cash advance provider versus a bank because I need the funds quickly and because it's based more on cash flow than a traditional underwriting. I'm more likely to be approved. If I have cash flow, I can be approved for merchant cash advance, whereas I might not qualify for a bank loan.
So how does this work when the bank, presume that the company already has some bank financing, already has a pledge of receivables and cash? How does the merchant cash advance jump ahead of the bank with respect to this transaction, or does it not?
I don't believe it does in that case. So as the provider of financing, MCA providers will typically file or may file a UCC1 that will put others on notice of their financing, the existence of their financing.
Will they finance if the bank already has
Well, that's
a
something.
UCC1 in place?
That's something for the MCA provider. No MCA provider would be reasonable if they went into a deal like this, which is very risky, without doing their due diligence. And so as part of their due diligence, the MCA provider is going to be asking those questions. They're going to be doing credit checks. They will do more than just review bank statements. So I didn't mean to describe the due diligence that they will do, because this is a risky form of financing. So anybody contemplating getting into this business wants to be very careful who they're advancing funds to. So that would be a factor that I think the MCA provider would absolutely be expected to investigate. And then they would want to put, again, the public on notice that they've done this financing and make the world aware of it, because here's a big risk that happens. It's called stacking. And that's that I've got an MCA in place, and I've purchased those future receivables, and now the merchant does what Greg just mentioned. They go out and they pledge my property. They've pledged those purchased receivables to obtain financing from someone else. Could be another MCA provider, could be a bank. So we want to prevent that from happening, and that's why we do our best, if you're supporting an MCA provider, to make others notified of the existence of this financing. But one of the biggest risks is something, again, called stacking, and that's where the merchant, even though contractually they can't do that, they go ahead and get more financing on their receivables.
Again, so let's just summarize the nature of the obligation that the merchant has taken on in our case, okay?
Right.
They have signed an agreement. They've signed a UCC-1 that pledges their receivables. And what exactly are they pledging? Are they pledging up to a certain dollar amount, or are they pledging a certain percentage, or both?
It's going to be both. Again, it's going to be both. Because
so I'm pledging up to $200,000 worth of receivables, for which I've received $100,000.
Right.
So, and if those receivables collect $200,000, then the merchant cash advance company takes all $200,000.
That's correct.
What if those receivables only collect $150,000?
Well, then in that case, it would simply continue to exist. The obligation would continue to exist until such time, if ever, we hit 200. Because again, there's no term for these agreements. So in that, and looking at the present value of money, my return is going to be a lot worse if it takes you 10 years to hit 200 if you ever do.
So it's a cap return. It's 200.
Yes.
And I fill that bucket with a percentage of receivables that are generated.
Correct. And we have a payment that approximates what that percentage will be. And the reason for the reconciliation, and I don't think we covered that enough, is the idea of the reconciliation is, we guessed it, what that amount should be. Now the merchant says, actually 15% of my daily receipts, which is all you agreed to take, is far less because I'm not doing well. And so the merchant can request a reconciliation. They provide bank statements to the MCA provider showing that, they can confirm the performance isn't what we thought it would be. And so let's reduce this payment downward to get closer to what a true 15% is. In other MCA...
But I'm not changing the 200.
No, it'll take longer to get to the 200.
Right.
But I don't want to bleed this merchant so that they can't continue to stay in business. So I give the merchant the opportunity to keep that as a true 15% a day by reducing the daily payment if necessary upon request and documentation.
Okay. Now, we mentioned stacking. The other piece of bad press that these companies have received recently is the so-called confession of judgment controversy,
right.
Which is outlined on slide 7. Many states have outlawed these in anything other than a commercial transaction, and of course, these are commercial transactions. So the way a confession of judgment works is you sign essentially a statement at the time that you exercise the MCA contract that says you waive any defenses you might have to the merchant cash advance provider going in and suing you. And when they sue you, they immediately get a judgment. You confess judgment, and obviously you could see that if there is the slightest twitter in payment, merchant cash advance companies might be tempted to use their confession of judgment.
Correct. And there was a case last year from the appellate division, First Department, New York court system, Champion Auto Sales, upholding confession of judgment specific to merchant cash advance. So that's a very favorable factor. But as Greg mentioned, there's been, in particular, a Bloomberg News investigation of confession of judgment gave pretty bad publicity, and Bloomberg's reported that New York Democrats are, contemplating possibly outlawing the practice. But as things stand, we have great court authority, appellate division that's higher than the Supreme Court in the state of New York, which is a bit odd, but their system's structured differently. There's very good authority that these are that can be upheld. Another thing I'll mention quickly is that so other states don't favor confession of judgment. You want to have an arbitration clause in your merchant cash advance agreement. Those clauses have been upheld, and you could succeed through arbitration in getting New York law upheld perhaps better than you could if you had to go to a foreign courts, and have them construe a New York confession of judgment.
Well, speaking of New York law and New York courts, New York allows its law to be exported to parties who potentially do not have any nexus to New York. Will other states respect that choice of law provision, or will you be forced, if you have, for example, a Georgia MCA company and a merchant in Virginia, but they have all of their agreements governed by New York law, neither of them has a New York office, although they may use New York bank payment processors and receivables companies, is that choice of law going to be respected?
It may or may not. So one of the cases I have in the material, Saturn Funding versus NRO Boston LLC, in that case,
Slide 10.
Yeah, Massachusetts Superior Court found that because the agreements were executed in Massachusetts by Massachusetts residents and a Massachusetts business through a Massachusetts notary, that they would not recognize the New York confession of judgment. So again, the courts are not bound to respect the confession of judgment. It's much more powerful if you have some presence in New York, which can be achieved potentially on the syndication side. But it's good to have some presence in New York to beef that up. In addition, another way to go about it is to have an arbitration clause. As I said, in the arbitrator is much more likely not to disregard New York law than a foreign court.
So the stakes are not just the confession of judgment, but also recharacterization of the instrument as a loan, and then the application of the indigenous law, in particular the usury statutes. So there's several things here that the merchant and the merchant cash advance company need to keep in mind to make sure that they each get the benefit of their bargain. The merchant cash advance company is going to want to use New York law. Obviously, minimum contacts to the state of New York and its forum, it would help. If you are outside of the state, then Mark is suggesting an arbitrator may be more willing to apply New York law, but of course they're not required to do so, and if, depending on how the arbitration clause is written, if there is court oversight of what the arbitrator is doing, you may end up having an appeal of the arbitrator's decision to a court. So there are some issues there. The most important thing, though, is you need to understand the indigenous law applicable to, let's assume there's no choice of law provision. What is the indigenous law of, in my example, the state of Georgia for the MCA provider and the state of Virginia for the merchant, and before you enter into those contracts. And then confession of judgment, which is an enforcement mechanism, gets layered on top of that and adds yet another dimension to the uncertainty.
There's a case cited in the materials on slide 11. I won't get into it in detail in the interest of time, but it's called Bistro Executive versus Rewards Network, Inc. And that's a California case from the Central District of California 2006 case. If you want to see how a foreign jurisdiction might view MCA in a way that's fundamentally much different than New York, read that case. It's a lengthy case. The facts are excellent. And one of the things I know here is that, well, the merchant cash advance provider, their internal policies, procedures, communications always referred to these things as loans, which was not good and came back to bite them big time. But it also just discusses the fundamental nature of how the court sees these instruments working and sees it as loan-like, not as a purchase and sale. So good case to read, to Greg's point, to understand how a foreign court, a foreign state might view MCA versus how New York views it.
Well, foreign as in not New York.
Not New York, yes. Well, that's true.
Still within the United States.
Yes, that's a lawyer's term. So
right.
Sorry about that.
But what's important here to keep in mind is it's not just a one transaction. Most merchants who do these end up rolling them over. Is that not right, Mark? And so you end up with potential of a pyramiding of the obligation, and that also catches the eye of the press and the regulators who think that, this is some form of predatory financing. But if we looked at it in a different way, instead of a purchase of future receivables, it was factoring, there would be no question, because in that instance, the property exists, the asset is purchased at a discount, the spread is what the purchaser makes as his profit, and the person selling the receivables is, shifting a risk of collection from himself to the purchaser of the receivables. All we've done with the merchant cash advance is pull that economic decision back in time to a point when the receivables don't yet exist. And so the two parties are trying to anticipate how best to structure their transaction in order for each of them to receive what they anticipate to be the benefit of the bargain. But reconciliation is not in and of itself deadly to the characterization of these as merchant cash advance forward contracts as opposed to a loan.
So reconciliation is considered critical because that payment, that daily payment, can be construed as a loan payment. And if it's absolute and you must pay a specified amount each day and there's no way to adjust it to reflect the contract that I've signed, which said you were going to take some percentage of my receivables each day, you run a huge risk of recharacterization as a loan. So I would say that reconciliation is extremely important. The only time you wouldn't need it is in some of these agreements. If you get X percent, and it's all based on card transactions, and you get X percent directly from the card processor, then I'm getting the true 15% each day from the processor, and I probably don't need to have some sort of reconciliation with the merchant. But otherwise, you need it, and it's considered to be a critical factor, and it makes sense as to why it's viewed that way. I'll say one other thing that's huge, because I have to mention it because it's very important, and that is that the clarity of these agreements is really important, crucial. You'll see cases alleging unconscionability, unfairness, and a lot of that is based on the fact that the agreement may not be understandable even by lawyers. I read some of these, and I'm not sure what they say. So you want to be sure that what you're drafting is very clear and not overreaching, because regardless of all the stuff we've just mentioned, if the agreement is not understandable and very confusing and comes across as grossly unfair, you're going to have a really steep climb in convincing anybody that this should be enforceable. So that's just a factor I mentioned. It's a little not as technical as the rest of it, but critical, understandable, big deal, understandable, and also fair.
So we've talked so far in our presentation about what MCA contracts are, how the courts look at them, things to avoid like confessions of judgment and personal guarantees, things that you have to have in order for them to be enforceable, like reconciliation clauses, and then the ultimate economics of the transaction, which is the purchase today of an asset to be created over time, and the limitations such as 15% of those cash of the receivables as they turn to cash up to a certain limit. So again, if you look at the analog of this as I've just purchased receivables that exist, it's a zero-sum game. If I purchase $100,000 worth of receivables for $50,000, the most I can receive is $100,000. If I receive 120, obviously that's a problem, and the contract wasn't properly drafted or someone made a mistake in the administration of those receivables. It's the same thing in an MCA. There is a cap, a limit as to how much you can collect from these. That's the outside number. The reconciliation potentially strings out the time in order to reach that outside number, and the amount of money that you get periodically as you try to refill the bucket back up to that outside number is a function, a percentage of receipts, and so therefore there is no, you must pay $10,000 a month or anything like that fixed payment schedule. So those are the distinguishing factors for these contracts. Now, this industry basically had its inception right after Dodd-Frank and has grown up in that sort of niche of the regulatory environment that I mentioned before, and you have many regulators, particularly state regulators, scratching their heads and saying, what are these things, how do they work, what do I do with them? Let's compound the problem and say, okay, you're a merchant cash advance company, you have millions of dollars out in purchased receivables, and now you want to recycle those investments, get cash, and do it again. Where do you get the money? So on slide 12, we've now moved away from banking law and UCC law into an area that should immediately pop into view, which is the securities laws. Why is this important? Who do you represent? And why do you need to respect or fear Section 29 of the Securities Exchange Act of 1934 as amended? It's important because you need to understand that once you create a participation or a syndication interest, or you sell notes that are backed by the merchant's cash advance company's balance sheet, you have created a security. You've sold an interest in something, and the regulators are going to say, how does that work? Should it be licensed? Should it be registered? Is there an exception applicable? What's the nature of the purchaser of the investment? So let's take the simple case where you have a company, a merchant cash advance company, that sells stock. Well, the stock is clearly a security. The merchant cash advance contracts remain on the books of the company that sold stock, and that company turns around, takes payments that it receives from the operation of its merchant cash advance business and pays them as dividends or stock repurchase to the investors in the company. The company has not sold a direct interest in the underlying merchant cash advance contracts. It has merely sold stock. Let's take a different example. Let's say the company has sold bonds or debt, even debt that's secured by the assets of the company. Again, who is the obligor? If the obligor is the merchant cash advance company itself, then you haven't securitized, you haven't passed through, you haven't done payment dependent or anything like that. You've simply borrowed money on a secured basis at the merchant cash advance company level. The return of those investors, excuse me, whether participating or not, is still interest payable to the note holders. And at some point, at the maturity of the note, the company will have to repay those debts either out of profit, through the issuance of more notes, or through the issuance of equity, essentially refinance that indebtedness. So just so we're clear, if a merchant cash advance company is issuing debt or it's issuing stock, it is the issuer. It has not sold a participation, even if the debt instruments that were issued are somehow secured by the assets of the merchant cash advance company. If that merchant cash advance company goes into bankruptcy, the creditors will, assuming they're secured, will have a superior position over the equity holders, and the bankruptcy court's going to sort it out, as it normally would, between secured debt holders, unsecured debt holders, and ultimately the equity participants. Many investors don't like that bet. And they try to say, well, I really don't want to be at risk of the vagaries of the collection business or of the merchant cash advance company's balance sheet. I want a direct participation in your loans. So take it out of the merchant cash advance context and think about a bank. If a bank sells a participation in a loan or a pool of loan to another bank, most securities regulators would say that is not the creation of a security, primarily because it's been happening forever. And when it's bank to bank, generally the federal securities laws and the state securities laws do not attempt to regulate that. The problem is many people in the merchant cash advance industry are former bankers, and they think they could do the same thing by going into the private investor market, raise capital, and sell a quote-unquote participation, and that somehow, some way, they've avoided the long arm of the 1933 and 1934 Securities Acts. And the answer is no, they haven't. The importance of Section 29 and why you need to fear it is if it turns out that an instrument has been created and it has been traded not necessarily on an exchange, but just between parties, the rights of the holder are, the capstone of those rights is rescission, meaning they can go to a court or to the SEC and ask that the transaction be not only unwound, but that the investor be given his or her money back. That is a disaster. And so understanding the nature, the true nature of what is being created, who is the issuer and or obligor of the instrument being created, what are the relative rights vis-a-vis the assets of the company and the so-called pledged collateral, all of that needs to be specified. Now, there is a tried and true path here. That tried and true path is to create a finance subsidiary or a syndication model where you create a bankruptcy remote trust, partnership, or other vehicle where that entity either issues debt or equity, and that entity purchases the MCA contracts in a true sale from the MCA company. That special purpose vehicle, that entity, that trust, then sells participations to investors, and it is selling securities. The pool itself may or may not be a fund because unless it can fit within the receivables financing exception under the Investment Company Act of 1940, you probably would have to say this is under Rule 3C1 or 3C7. But that's okay. Again, hedge funds and private equity funds have existed for years. This is just another form of private investment fund where the asset underlying it may or may not be a security. And so to be conservative, you would assume it is a security and follow the rules applicable in the same way that CDOs and CLOs always had a 3C1 or 3C7 backup when they were all in vogue back before the financial crisis that prompted Dodd-Frank. If you look at page 13, the question is asked, what is a syndication? Debts are issued by a consortium of lenders to a sole borrower. There's a lead lender or arranger for the consortium. The lead is responsible for facilitation of the loan and allocating cash flows. These could be underwritten deals, club deals, best effort syndication deals. But none of those questions go to the heart of what it is that you are buying as an investor. If you go to slide 14, you have 40 Act issues, tax issues. Does the holder of the participation have debt or equity? Who has custody of the assets? Do they have legal competence? Do they understand that once they have custody, they have a fiduciary duty? So, again, applying a rule of thumb, The best answer is to say that that special purpose vehicle is a fund. It has a separate custodian that holds the MCA assets, that it's purchased from the MCA company in a true sale, and then that special purpose vehicle issues either or both debt and equity to investors whose rights are defined by the indenture that creates the special purpose vehicle. And then over time, as the payments are received, those investors, debt or equity, get paid. The problem that you have with taking the structure I just outlined, which we know works, and the MCA business is scale and cost. As Mark said, most of these MCA contracts will have a relatively short life, anywhere from 10 months to 24 months. The cost of a securitization structure can be very expensive because of the need for the due diligence, the indenture, etc. So that means a more efficient model needs to be created. And perhaps the best model is going back to something that's, again, as old as the 1940 Act, a hedge fund model, where you set up a fund, a structure, a partnership, an LLC, a trust, that invests, that purchases these assets, but that ultimately can replenish the asset pool as the underlying assets are repaid. The problem with the hedge fund model is it's open-ended and has the need for someone to value the portfolio so that investors can come in and out. In order to obviate that concern, you need to go with a closed-end model, or a model that's been used in private equity for years, where a sum certain is established. Yes, there can be a period of reinvestment, but once the reinvestment period is over, the assets go into runoff mode, and whatever is collected is paid out to investors. So we hear, Mark and I, a lot of people banding about the idea of participations. If you go to slide 17, participations are not loans. They are contractual arrangements between a lender and a third party in which the third party or participant provides funds to the lender. The lender in turn uses the funds from the participant to make loans to the borrower. If the agreements are true participations and thus sales rather than loans, then the funds are effectively removed from the race of the estate. Now, of course, this is a participation case defined in the context of an actual lending business, not an MCA business. But the principles still apply. If you turn back to slide 15, here's two excerpts from a participation contract. The participant shall have no interest in any property taken as collateral for any other loans or extensions of credit made to or for the borrower by lender, or in any property in possession or control of the lender, or in any deposit held or other indebtedness owing by the lender, which may be or may become available for payment of the advances by reason of the general description of secured obligations contained in any security agreement. Okay, Mark, translate. What are we actually saying here with these two clauses?
You're basically saying, I believe, that you take all of your rights from the lead and not from the underlying basis for, whatever the underlying asset. I'm taking whatever rights I have from the lead participant. I don't obtain any right in any of the underlying assets that may be generating income.
Well, that's one thing, but it also says that I don't have any right in any deposit held or indebtedness owing by or to the lender. So in effect, this is an obligation that is unsecured, right, and purports to directly participate in the designated pool of assets. But when faced with these questions, I always ask, what happens in bankruptcy? Who ends up holding the right to the underlying asset? And as a participant, are you just an unsecured creditor of the bankrupt estate, the MCA firm, and are you just an unsecured creditor? And unless you have a UCC-1 filed in your favor, you are an unsecured creditor, because these participations are not in segregated vehicles. They exist only as a share of assets and revenue generated by the MCA firm. If you go to page 18, elements of a participation: money is advanced to a lead lender. Participant's right to prepayment only arises when a lead lender is paid. Only the lead lender can seek legal recourse against the borrower, and the document is evidence of the party's true intention. So one way that you can potentially make these participations work is where, as a participant, you essentially get novated in as a participant in the underlying participation contract. So Mark and I have worked on certain novation arrangements where the participant is no longer in privity of contract with the MCA company, but rather is in direct privity of contract through a novation with the merchant. Now, the MCA company still acts as the agent, the collector, and the quote-unquote lead, but the MCA company is no longer in the chain of title, so to speak, or booking the bet or guaranteeing payment to the MCA participant. All of the MCA participants' rights are in direct privity with the merchant. So if you're looking at a debtor-creditor relationship, page 19, if there's a guarantee of payment by the lead lender to a participant, you probably have a loan, not a participation. If the participation lasts for a shorter or longer time than the underlying obligation, again, you're looking to the lead lender as the debtor here, not the underlying. If you have different payment arrangements between the borrower and the lead lender and the participant, or if there's a discrepancy between interest rates due, then you are looking probably at a situation where you've actually lent money to the MCA company as opposed to being a true participant. In Ray Golden Plan of California, page 21, slides 21, where an investor receives no contractual guarantee of repayment or compensation in the case of the borrower's default, such assumption of risk strongly suggests that the investors are not in a debtor-creditor relationship with lender. So once you introduce third-party money, it raises a whole host of issues that need to be addressed. Probably the most important one is, what is the investor buying? Who do they have to look to for payment? Do they have rights that are larger than the rights of the participation that they have? Even if the contract attempts to limit those rights, again, if the nature of their claim is that of an unsecured creditor of the MCA firm, you haven't done anything other than issue a debt instrument or some form of security out of the MCA provider. So our last slide is the Howey test. What is the security? From the Supreme Court, an investment of money in a common enterprise with the expectation of profit from the efforts of others. Well, the efforts of others here are simple. That's the MCA provider. Have you invested money as a third-party investor? Absolutely. I wrote a check. Is it a common enterprise? And is there an expectation of profit? Clearly, there's an expectation of profit. The question is, when I become a participant, is there a common enterprise in the MCA firm, or is there a common enterprise just in the instrument that I purchased? And are there other potential participants? If there are multiple participants, you have a common enterprise, even if it is just one MCA contract. And then you have to ask yourself, who is booking the bet? Who is paying me? And if I am being paid by the MCA company, and I am at risk to the general creditors or secured creditors of that MCA company, then I have not bought a participation. I have bought some form of security issued by the MCA company. Because of the uncertainty, and there's a huge amount of uncertainty here, you need, as an investor, to be extremely careful And my advice to you is, as an investor, you want to buy a special purpose vehicle instrument, either an equity instrument or a debt instrument issued by the special purpose vehicle, where the assets are purchased in a true sale from the MCA company, where there is a bona fide custodian, a bank or a brokerage firm that actually holds these assets, or maybe the NCA company can hold them, but they hold it under an exception under the securities laws, where the advisor to that SPV vehicle may actually have to be a registered investment advisor. Yes, it's a new asset class. Yes, the rules have yet to be defined around it. No, this is not rocket science. And there is an ability to use the tools that have been laid out for us for the last 70 years to protect investors and to protect the MCA provider. Any parting words, Mark?
Yeah, so Greg, let's say that I take the model that you suggested might be available, where I go to the let's call them the MCA lead, and now they give me an opportunity to, I can actually be a party, a true funder of an MCA contract through innovation. How does the Howey test play out then? Do I still have a common enterprise? Because now I'm in privity of contract with that merchant, and I'm truly an MCA provider in my own right, correct? I'm a co-founder.
Yes, you are. You are MCA provider in your own right. And then the question is, have you simply extended credit of some sort or bought an asset where you're not under the Howey test, but perhaps under the Rivas test, which is another Supreme Court decision dealing with these types of instruments. And there, the extension of credit in a commercial transaction or the purchase of receivables is explicitly accepted out of the securities definition. So by going direct with innovation, you arguably now fit within an exception outlined in Rivas.
Except that if under my agreement with that MCA lead, the MCA lead says, look, you're in privity of contract with the merchant, but you can't do anything. I have to control this entire investment. I'm the only person that can deal with the merchant. I'm the only person that can collect from them. I'm the only person that can decide whether or not this deal still is viable, or I can just deem it to be in liquidation. Now, could there be a risk that I'm so passive that somebody says, well, actually, I'm still totally reliant on the efforts of an MCA provider, and therefore, this is a security? Or would the fact that I am technically in privity of contract get me out of the Howey test still?
Well, the privity of contract basically goes to the common enterprise. Because if I am in direct privity with the MCA consumer, the person who's, I hate to say borrow the money, but taking the merchant cash advance arrangement, and I'm in direct privity with that person, where's the common enterprise? So arguably you would get out of Howey that way.
But you'd still have an issue that it could still potentially be a security.
Correct.
Under
And so the best answer for all the parties involved is to embrace regulation. Assume it's a security. Make sure if you're the merchant cash advance company that the people who are participating are accredited investors. Disclose the risks of what's going on. Perhaps even file a Form D with the SEC. And if you have an open website, make sure you verify accredited investor status and fit them under 506C. The easy answer is, again, embrace regulation, treat it as if it's a security, even if you don't know it is, because it can't really hurt. All you've done is raise the bar for your competition, and you've given investors disclosure, you've given investors information, and you've given a blueprint to the investors on their understanding of what it is that they've actually bought. So the better answer there is, since we don't know how a court would rule or what the regulators would say, assume that they will say security, in which case you say there's nothing dirty going on here. We've ticked every box as if this were a security issuance. The only thing we didn't do is put the word security on the front cover. So, a very interesting area of law. We look forward to discussing it with all of you over time, and thank you for your attention.